Welcome to this session of the Commission's interviews, Mr. Thulare, and thank you for availing yourself for consideration for appointment as a judge of the Western Cape Division of the High Court. You hold 3 degrees, is that right?
That is correct, ACJ.
It's a B.Juris degree, it's a Bachelor of Law and a Master of Laws. And you got all of them from UNISA?
That is correct, ACJ.
Yes. You got the B.Juris in 1996, you got the LLB in 1998, you got the LLM in 2002.
That is correct.
I see that you said the LLB is a Bachelor of Law. You didn't say it's a Bachelor of Laws. Is that because it's not the normal LLB?
It's a Bachelor of Laws.
Plural.
Yes, the plural.
Yeah, because I think a Bachelor of Law would be a B.Juris.
That is correct.
Yes, okay. But you got your LLB within 2 years after your B.Juris. That was pretty fast, isn't it?
That is correct.
Wouldn't an LLB normally take longer if you are not full-time, or were you full-time?
No, I studied part-time throughout.
Yes. When had you started studying for the LLB? In 1997? Immediately
after my B.Juris, I commenced with my LLB. And immediately after my LLB, I proceeded with my LLM.
Sure, that was quite, because UNISA's LLB used to take quite some time for people who were not, who were working. So you did it quite quickly.
Thank you, ACJ.
Yes, okay. Now, you have been to this commission for interviews a few times, is that correct?
This is my 3rd time, ACJ.
Okay. It's not many times, it's just at that time. Yeah, okay, no, that's fine. That's fine. Now, you started your working career as a general laborer at SA Breweries, is that right?
That is correct.
In 1989?
Yes.
In 1989. And you remained in that company up to 1991?
Yes.
And then in 1991, you were appointed as an interpreter in the Department of Justice?
That is correct.
And you continued in that position until 1996, when you decided to go and do articles, is that right?
I became a prosecutor from being an interpreter, ACJ, between 1996 and 1999, and then I went to serve articles in 1999.
Oh, you're in the questionnaire. You, after interpreter, you indicated that you were a candidate attorney from 1996 to 1999 at Dupree and Coase Incorporated.
If it reflects so, it must be a mistake, I have to say. But you'll see through the attachments that yes, I was a court interpreter, and then I became a public prosecutor. Yes. And I went to serve articles, and then I became a magistrate. That's the path of travel.
Oh, okay. And you didn't put the prosecutor here. You must have forgotten. But you say in the attachments, there is something that indicates.
Yes, attached to my application, the path of travel, I made sure that I make copies of the documentation that I have, supporting documents, ACJ.
Yes. And then you were appointed as a magistrate in 1999, is that right?
That is correct. I started acting in 1999. I was appointed permanently in 2000.
Oh, okay, yeah. Okay, well, here it reflects magistrate from 1999 to 2005.
Yes.
Yes. Okay, and then you were appointed as a senior magistrate from 2005, and you held that position until 2016.
That is correct.
And you were appointed chief magistrate from 2016 to date.
Yes.
And in the different levels as a magistrate, were you exposed to civil work?
Yes.
Adjudication of civil cases?
That is correct. When I joined the magistracy, I was appointed as the magistrate for Johannesburg.
Yes.
Now the Magistrates Courts for Johannesburg has got what one may call specialist functional areas. When you work in the civil courts, you do exclusively civil litigation. And that's why I started.
Yes.
And subsequent to that, I also got involved with judicial training. I trained other magistrates in civil litigation. The commissioners should also recall that I also mentioned that when the Department of Justice took a decision in the project that they called Taking Justice to the People, converting courts in townships which dealt exclusively with criminal law to introduce civil and family, I went to establish those courts, in particular Soweto, Davidton, and Mamelodi. I trained magistrates in civil and family and also recommended their appointments to the minister. And they are, as we speak, courts that do all services of a magistrate's court.
Now, in terms of branches of law, the civil work that you were exposed to as a magistrate would have included what branches of law?
Contract, delete, motion court, almost everything that a magistrate's court does, including disputes relating to human remains. You know, on a Thursday afternoon, when families fight over where a person should be buried, in terms of the regulations to the National Health Act, magistrates do those disputes. Yes.
Okay. In paragraph 8 of the questionnaire, you were required to furnish particulars of your membership of any political organization, past and present, and you indicated ANC and that you were a member from 1990 to 2006. Is that correct?
That is correct.
But from 1999, you were already a magistrate. How did it happen that you continued to be a member of the ANC while you were a magistrate?
We grew within a judiciary in the lower courts that came with its own baggages. And magistrates ordinarily, when at the time that I was an interpreter, I'm talking about before 1994, soon thereafter, magistrates participated in that space, and until the Magistrates Commission took some resolutions, and then we stopped. Yes.
Now, when you say magistrates, I guess what you are simply saying is for a certain period, magistrates, it was common for magistrates to be members of political parties.
Exactly. I can just give you an example, ACJ. During the referendum, whether South Africa should go into a constitutional democracy and what, magistrates openly wore Conservative Party and National Party colors to courts. That's the space in the magistracy that I observed.
Yes. Would this phenomenon of magistrates being members of political parties have been confined to white magistrates before 1994, for example, or was the position that even black magistrates also did the same?
It was across the board. That's why when we started moving to the realization that we are a part of the judiciary and we can't do that, we got rid of those practices that are antithesis to judicial office.
And did you say that this stopped only when the Magistrates Commission intervened and made a ruling or something?
And the debates within the organized profession of the magistracy, yes.
Okay, and when was that?
I have to say, some of the resolutions that I recall of the Magistrates Commission were specifically in 2005 in relation to in which areas magistrates should participate. Yes.
Okay, and you have been acting in the High Court for some time, is that right?
Yes. As of now, for both Johannesburg and Cape Town, I would have acted. I'll be in my 10th term because now I'm acting currently in the Western Cape. I'll be in my 10th term.
You have been acting continuously for quite some time, is that right?
Except for 2019 and 2020 and this year, it wasn't continuous. The only time that I acted for a full year for all the terms was 2018.
Okay. Judge President.
Thank you very much, Chief Justice. Mr. Thulare, there are two problems in my view which confront judicial officers in the Western Cape. One is racism and the other one is forum shopping, whereby if a case is allocated to a black judge and we have these high-powered counsel, particularly white male advocates, they would find excuses to run away from that black judge to whom the matter has been allocated. How do you think, do you have any suggestions as to how we can minimize or eliminate or eradicate forum shopping?
I think case management, it's necessary. In that my own sense is once a matter has been allocated to a judge, I would enjoin that judge presidents return that matter to that judge whenever it is placed on the roll again. That's one of the strategies, because what happens is there would be one or more reason as to why parties would seek a postponement. Sometimes they would say we are trying to talk settlement, and then the case gets postponed because they are talking, and then they would try to re-enroll it, hopefully with the idea of getting another judge. But I think if we get a system in terms of which once you're allocated a matter, you are deemed to be seized with that matter, it will mitigate.
Any other views in that regard?
I think there should be a way of calling out this council. I'm just not sure yet on how we should do it. But I think sometimes naming and something with its true name makes sure that things do not fall in the cracks, because people realize that you are being noticed. Yes.
Thank you. Thank you, Judge President. Ms. Stewart, I give you the opportunity now to put questions to the candidate if you wish to.
Thank you, Acting Chief Justice. Hi, Mr. Thulare. I have two questions for you. The first is, in the comments by the General Bar Council, they mention a matter of yours that has gone on appeal, which you don't mention in your list. They cite it as S versus Cooper. It's quite oddly, it's got an odd citation and I couldn't find it. Do you know of another case of yours, S versus Cooper, that went on appeal and it seems it was successfully appealed?
It was a petition, if I recall correctly. Yes, it's a matter. It was a full bench matter. I sat with I'm trying to remember the name of the judge because I am used to referring to him as Braden, Judge Dlodlo. All right. I sat with Judge Dlodlo in that matter. He was the senior judge. We agreed on what the position was. If I recall correctly, it's a matter that dealt with the maintenance of a child. It went to the SCA, and indeed the SCA found otherwise. That is correct. I have to say that I became aware later because sometimes we do struggle, especially if it's not a full written judgment that comes back. Sometimes it becomes difficult for one to trace these judgments whenever they go for higher relief.
Yeah, thank you for that. And the second question I have is, in the realm of administrative law, there's a difference between an appeal and a paja and an appeal under the principle of legality.
It would be a review.
Sorry, not an appeal, a review. And I'd just like your understanding of the difference between the two types of review and how that difference came about.
One always visualizes, a big coat covering a number of children underneath it when one speaks to paja, because remember, organs of state and officials, especially officials of the state, took an oath of secrecy in the old dispensation, and as a result, the general public and ordinary men and women would not have access to the information that functionaries of the state would have had and the decisions that they made. It is against that background that I think the founding fathers of the Constitution decided that we must have a different approach and philosophy in relation to how we deal with administrative acts of organs of state. And that's how I understand the review under paja, to say it must be a lawful a decision, it must follow a particular process, it must be reasonable and fair. And that's the review under paja. And then you have other decisions like one state department against the other, and/or decisions of the executive, for argument's sake. Those who are not organs of state, but you need to have those decisions revisited, and that's the other review.
Okay, thank you, Acting Chief Justice.
Thank you, Commissioners. Commissioner Nyambi.
Thank you, SCJ. Evening, Mr. Thulare.
Good evening, Commissioner.
I have just one question. As SCJ has indicated that we have interviewed you 2 times in the past, probably something that you think is significant that we must consider that might have happened then and now that will make you to be one of those to be recommended this time around?
You grow as a person and you learn, all right? And you can assess from the questions that the commissioners are asking areas of concern, and you work very hard towards improving yourself on those questions. I do not regard myself as a person who's beyond correction, and there are lessons that I have learned from the questions, some of them critical, that have come across through the past 2 interviews. And I have grown as a person, I have grown as a judicial officer, I have grown as a state official.
Thank you, Mr. Thulare. Thank you, SCJ.
Just as a follow-up on that, on Commissioner Nyamba's question, I would encourage you, if you are comfortable with this, that where you think you may have done something that deserves correction, and you think you have realized it, that you feel free to share that with the Commission. I say that because although I wasn't here in the April interviews, I've read part of the transcript. So I'm not asking you to do anything you are not comfortable to do, but I'm just saying if there is something that you might have looked at and said, look, maybe this I could have handled differently. I just want you to encourage you to consider doing that. You understand that I'm not saying do anything you are not comfortable to do.
Yeah, no, I'll touch on one thing which is very important for judicial office, and which I gathered was an area of concern, and that is the speed with which one delivers judgments, especially in urgent matters. I do not want to sound to justify the judgment that was the subject matter of discussion, but I approached, for instance, the position from the fact that degrees of, insofar as I understand the law, there are degrees to agency. In the example that I gave, where parties come and argue over who should bury, you can't take a month to decide. You have to decide within a short space of time. And I had occasion to deal with a matter which came, it was property that was seized related to allegations of proceeds of crime. And the matter came before me because the person whose property was taken claimed that they want access to some of the funds to deal with, to cover their maintenance needs, as well as funds for litigation, including provision for the possibility of an appeal to the Supreme Court of Appeal, including to the Constitutional Court. And because this was, the maintenance part didn't give me problems, but the area related to whether funds should be released, and if so, at what quantum and what criteria one should follow in determining that, I took time around that. And that related to the criticism that was leveled against me in relation to that. And I've learned from that to say, look, an urgent matter is urgent, and perhaps one should reflect on these matters and make sure that it is a concern. I've also watched some of the interviews, not only during this session, but in the previous sessions, and I've seen that it is a theme of the commissioners that judgments should be delivered expeditiously. And that got to me. I got the message loud and clear, Acting Chief Justice.
Thank you. Minister?
No, thank you very much, Magistrate Thulare. Good evening.
Good evening, Mr.
Yeah, for sure you have seen that we have been here since Monday, and today it's a Friday evening. Seeing you coming at this time excited me, because in the last interview I heard for the first time that you can sing very well. So I thought we will be woken up. My question, Magistrate, is my question relates to, I see that one of your stints you worked for the South African breweries.
Yes.
And during this period of COVID, as government, we had a lot of back and forth with the liquor industry.
Yes.
What is it that you think, if you are brought into the judiciary, you will be able to help this country with in terms of your interpretation in relation to responsible drinking of alcohol and the manner in which you will deal with matters that might relate to this industry that will promote responsible behavior with regards to alcohol, because most of the social ills, it has been proven, does come from this. And I'm sure when you work for the breweries, you have some, you may not be having an expertise, but some general knowledge, and you might still be interested.
Sure. Yeah. Good one. So this. Yeah. You're offline. Okay. The camera is on the remote side and
Let's create the quest, please.
so when it's on the remote side, then when you don't have control with, unless, but if it says it's offline, then how you can activate it offline? Yeah, that's what I mean. I mean, you can't get Koyo alone from the offline. Thank you. This is the office. Oh, I'm pulling in one. Right. Let's say the plan can do for you. I want to gain the. So there's a lot of event. I'm the isolated because so I'm going to die. Okay, so you're doing like. I don't know when you don't do the application money thing again. That good job. I see. It's probably the version of the monitoring software inside for the camera or slow vision in itself. Yeah, when it's offline. The fact that the application states that the device is offline whereas it's online, there's something wrong with the application, not the device. Yeah, well, it's not been a bug, you look nice. That's what it means.
interested in this industry.
Minister, one observation that one makes in relation to alcohol and to an extent also drugs generally is that the criminal justice system's response, in my view, tends to be inappropriate. And I think there's one judgment that forms part of the pack where I hold this view, that whenever a person comes to court and the person is convicted of what one may call a social ill, and or perhaps an illness, a punitive sanction does not help, in my view. So you need to put in programs in place, psycho and social interventions to deal with the abuse of alcohol and drugs. And noting that government ordinarily does not have loads of cash to deal with that. In my view, it is those who benefit financially from exercises that avail these substances that leads to problems, who must then make some form of a contribution in the programs that we put in place to assist those who are struggling. Because if I have worked in a court, the Magistrates court, which deals with persons who have got problems with the drugs. What I have learned is that, and even abuse of alcohol, what I have learned is, in the main, there's always an underlying psychosocial, if not a psychiatric problem. So we are not addressing the real issue by sending the person to Portsmouth for 6 months. We are not addressing the underlying problem. And that's where we should dig. And in that digging, these institutions that then derive an income from providing these substances must be engaged to provide resources for the programs.
Thank you, Acting CJ.
Thank you, Minister. Commissioner Totovu.
Thank you very much, ACJ. Good afternoon, Mr. Thulare.
Good evening, Commissioner.
I'm closely observing you, and I'm thinking of what happened during the April interview. I see much difference. I'm inspired by your articulations and even how you respond to questions. And for me, this is quite important. It shows some improvements in that respect, because personally, I didn't like that singing and all of those sorts of things. With that in mind, do you understand the principle of, or the doctrine of double jeopardy?
Yes, I do.
Well, what does it mean in the context of this commission and what happened in April?
Can I ask your protection, ACJ?
In that sense, I meant that let bygones be bygones.
I was not in April.
It's okay, you can't be punished 2 times for the same crime. All right, thank you.
Thank you.
Okay.
Sorry, SCJ, that is on condition that he gives us a live performance.
Commissioner Mpofu.
Thank you, DCJ. If you want a lawyer, I can represent you. If there's any double jeopardy, you are not involved. Yeah, thank you. Mr. Thulare, I just wanted to ask you, there's one curious fact about the Western Cape bench, which is this, I don't know what you call them, two bench sittings in civil matters.
Yes.
Which we don't do here. So I want to ask you firstly about that. Well, let me ask it like this. Here we develop skills to ask two questions and make it look like one so that the DCJ doesn't detect it. So I want to ask you that question in relation to the difference between the magistracy and the bench, because obviously as magistrates you always sit alone.
Yes.
So how for a person who has been in both systems, how do you deal with that difference, and what does it really signify for you, or rather, what are the characteristics of this two bench thing, particularly in relation to the following issue? What happens when you differ if the two persons hold a different view? Because we know that one of the reasons for the odd number configurations, full bench 3, SCA 5, Concord 11, theoretically, is to use that for the tie breaking, as it were. In the two judge bench, how do you deal with those?
Look, let me start by saying the difference of opinion between judges should not be viewed negatively. It is quite enriching, not only for the judges themselves, but for our jurisprudence. So what happens is, let's say for argument's sake, the JP allocates a matter wherein I sit with him. I would read the papers, and once I have formulated a view, I inform him as the senior judge to say, JP, I'm ready. And then we engage. He obviously leads the discussion, but the crux of it is to determine what my view is and whether in fact we agree. Now, where there's a difference of opinion, there is engagement first. All right. It's not a question that I stand by my position and he would stand by his position and that's it. We try to see if actually I can understand the world from the doorway he's standing, and whether I can take him to the window where I'm standing and he can see the view, because the views are different. It is only in instances where after that engagement and that exercise, we can still not find each other, that he will have to make a decision on the way forward, whether to constitute an entirely new bench altogether or to add another judge, so that we are three, and then we'll go through this same exercise. If it's an additional judge, we'll give the judge an opportunity to read, and once that third judge has made up a view, and then we come for the conference, we discuss. All right, and obviously, there's generally no third view. There are only two views to a question. So one of us would be outvoted, and that would be the decision. And then it goes to the writing then. If I feel strongly about my view, I'm obviously going to write a dissenting judgment on the understanding that the other judge agrees with the JP. So they would write their view, and I would also write my view. And that, as I say, difference of opinion between judges should not be viewed in a negative light, to say they don't know what they are doing. It's actually enriching, and it's a setting. It's a demonstration to South Africans that we actually apply our minds and think independently on the papers before us.
And yes, the follow-up is the experience of coming from a bench where you always sit alone versus sitting in a panel. How do you transition between those two?
Yeah, in the beginning, it's a little bit strange, especially where you find that it's easier where you agree with the judge. But when you hold a different view, and especially as a junior judge, sometimes you reflect and reflect. It's only when you have written the third draft, personally, it is only when I have my third draft and I still cannot agree that I would stand by my position.
Okay, thank you, Chair.
Thank you. Commissioner Mpofu, is a follow-up another way of disguising two questions?
To get a third question.
Commissioner Nochesi.
It's just a follow-up. Tell me on this, there's something that troubled. Is it permissible for judges to then, in the context, to discuss matters among themselves?
There is nothing. I have to be very careful here, I think, in the context of the climate where I find myself. But let me say, discussions amongst judges, in my view, should be encouraged. It shouldn't be discouraged. Because as I say, it helps a lot. Let me not speak about the judges. Let me take you to the scene of the Magistrates Court. The tea room is a learning center. The tea room of a Magistrates Court, it's basically a workshop session. All right? When I'm sitting with a matter and there's an argument by Mpofu SC on a particular point, and I've got a particular view on it, I bounce it with my colleagues in the tea room during tea break. There's nothing untoward about that. All right. Yeah. Let me rather stick there at the Magistrates Court and not come to the High Court. Thank you.
Thank you. Thank you. Commissioners on the... Oh, I'm sorry. And you, Mlambo JP, I didn't put you down, but you can go ahead and then... Oh, I've got, yeah. Mlambo JP?
Acting Chief Justice, I think Commissioner Tsepe was before me long time. So yes. I'll ask her to speak before I speak. No, can I continue?
This side of me is confusing me. No, it's fine. Let's go to her. Yeah. Commissioner Tsepe.
Thank you, Acting Chief Justice. Good afternoon, Mr. Thulare.
Good afternoon, Commissioner.
Mr. Thulare, I'm sure you would have been provided with the comments from various law bodies,
yes,
including that of the General Council of Bar.
That is correct.
In paragraph 15 of their comments under the heading, the candidate judicial temperament.
Yes.
They raised issues regarding your judicial temperament, and they referred to 2 incidents in that regard. Would you care to comment on those issues and discuss? Did you have an opportunity to look at that? Yes,
I think I've provided a written response as well to the commissioners. But let me say, the matter was in what we call the 3rd division in the Western Cape. That is the unopposed role. All right. Now you sit generally with around 60 or more cases during that time, 2017. All right. So it is a debt of a credit card incurred by the mother of the house. ABSA approached, issued summons against the mother. They came to court. What they claimed was foreclosure of the property owned by the mother. And the issue of the father not being there and being a joint owner arose. That was before I became engaged. I'm just setting for you the background. Then the father gets joined. Then he gets served with the process. And then there is no notice of intention to defend file. The matter comes before me on the 31st of October 2017. It is a request or a prayer that I must declare the property of the family specially executable so that they can sell their home to recover a debt of around 160,000 or just over 160,000 of monies owed. All right. Now, in ABSA's own papers, they indicate in an affidavit that 2 days prior to that, 3 days, on the 28th of October, there's an attorney who contacted ABSA's attorneys of record and indicated to the attorneys of record to say, I do not have instructions to enter an appearance to defend and join issue because the family says they do not have money for high court litigation. They are prepared with what they have to settle the debt. All right? That's an affidavit that's on the papers. I come into court, counsel rises when the matter is called, husband and wife rocks up. Now, immediately you can, with regard to a default judgment, there are those two legs, absence and a defense, right? The absence is already doubtful because husband and wife are physically inside the courtroom, but there is no notice of intention to defend filed, all right? Against this background, I engage counsel to say, but where the parties indicate that they are willing and able to settle or make a payment rearrangement, is it not proper that we give them the opportunity to engage with your attorney? All right? And it is that which led to the undertaking by counsel, amongst others, when the matter gets postponed, because I postponed that matter for that very reason, that the parties then need to talk. All right? I postponed the matter to a date. Counsel undertakes in open court that they will provide the details of the attorney to husband and wife. That's the end of the matter. They leave the court. Now, understand the setup at that time. As I say, you have around 60 matters. You first deal with removals and strikes offs, and then you start with these default judgments. So it's very early. And it's the unopposed roll. The courtroom is full. Remember, on my roll, there are divorce matters, there are Rule 43s, all these other matters that are dealt with in the division. So the courtroom is still full by that time. Counsel undertakes in a full courtroom that they will provide, and the matter is postponed. I've dealt with that matter, that's it. Soon after they've left, husband and wife comes back. And you can see that they're upset, and you can see that they need the attention of the court. All right? I give the attention to them after I dealt with the matter that I was dealing with then. And then I get advised that when they left, counsel did not want to talk to them. He simply left them and walked away. All right? And it is against that background that it is happening in open court. And remember, we are in the Western Cape. All right? The family is black. You have a black judge. Counsel is white. All right? And this is the treatment against the background of South Africa. All right? I know, and that is why I made a comment to say the legitimacy of the court processes, the decorum of the court, and the trust of court officials, it's bigger than Daniel Thulare and Lauren Bosman. So I indicate to them to say, if that's what you have experienced, I do not expect what you are reporting to me from an officer of the court. And I apologize to you if that is what you have experienced. But what I can suggest to you is the matter stands postponed to the 31st, or I think it was the 10th of December or somewhere around, to say the matter stands postponed to that day. Make an effort to first go to the bank, and the bank will indicate to you who their attorneys are if they can't help you themselves with your offer. And also go back to the attorney that you had talking to APSA's attorneys so that the matter can be taken forward. That was the end of the matter, all right? The next day, I got to know through the registrar that Van Rooyen SC wants to see me and she wants to come with Advocate Bosman. And it's in relation to discussing what happened the previous day. I did not understand that to be a complaint against my conduct, because I can tell the commission now to say, had I understood that I was actually the subject matter of that meeting and my conduct for doing what I did, I would have said, well, I've got a leader. I want the judge president to know. But because for me, it was something that happened outside the courtroom, and the advocate wanting to explain to me what had happened in the presence of a senior counsel who's involved with training, I didn't even deem it made to inform the JP about it. We spoke about it, and for me, that was it. And that is why I was taken aback about what was then narrated. But that's the context of what happened. It is unfortunate that I went back to, you'll see from my response that I actually wanted the transcript of the record, because it wouldn't have been a long transcript. It was short proceedings. But unfortunately, I couldn't get that. But that's what happened.
Thank you. Thank you. Commissioner Schlemmer.
Thank you, Chief Justice. Good evening, sir.
Good evening.
I just want to ask you about something that you said when I think it was Commissioner Dudor who asked you whether you have kind of reflected on everything that went past in the last two interviews. And then concerning the delayed judgments, you said that you looked at some of the previous interviews and you realized that it is important for the commissioners. Is that the only realization that you have? I would like to know what you think about the fact that we do feel it is important that judgments should be delivered on time. I just want to know what your sense of that is, because your answer didn't tell me that you really reflected as to what the meaning is of delivering judgments late.
No, I have accepted the sense of agency, and I've learned from that. That's what I conveyed to say. I had moved, as I indicated, to say I had moved from the premise that there are degrees of agency. You know, there's something immediate, and with a matter that's a little bit that needs some time, because I have to state this. I wrote a full judgment on it. I just didn't give an order to say I'll write reasons later, which is a practice that I don't necessarily like, which is perhaps what I ought to have done, to give an order and then provide the reasons later. All right, I wrote a full judgment, and the judgment was accepted because it was never taken anyway, which means I explained the position as I understood it. But the point that I was trying to make was to say, I have taken note that judgments should be delivered expeditiously. And that message got across loud and clear.
It's because justice delayed is justice denied, sir.
Yes, that's true.
Judge President Mlambo.
Thank you very much, Acting Chief Justice. Good evening, Mr. Thulare.
Good evening, JP.
Just a basic question, if you don't mind. You're sitting in the Western Cape Division of the High Court. You're doing a trial, and you're confronted with irreconcilable versions. How do you approach the matter? How do you deal with it?
If it's two irreconcilable versions,
yes,
then I go on to assess the truthfulness of the versions and the credibility of the witnesses. And if I find that on the balance of probabilities, the plaintiff has proved their case, I will find in their favor. If I find that they didn't, I dismiss.
Thank you.
Commissioners on the virtual platform, any questions?
Thank you, SCJ. I'm covered.
Thank you. Nobody else? It looks like, thank you. It looks like we have come to the end of this interview. Thank you very much, Mr. Thulare. You are now excused.
Thank you, SCJ, and good evening to everyone.
Full of energy, why didn't you pursue LLD or PhD at the time?
I started a family in the meantime, and priorities changed. But now I am busy with my LLD, Chief Justice.
Which university did you register with?
I did my proposal with UNISA, and now that I'm in the Western Cape, I decided to join what they call the Bush, the University of the Western Cape. I'm a registered LLD student there.
When did you do so?
I did my proposal in 2019, and I moved, in the course of last year, I moved to UWC.
Wow, I envy you because I did my proposal. I registered, I think it was 1990, 1991, and dropped out. And I gave myself an excuse that I was too busy in private practice to focus on a doctoral degree. And you've been a judicial officer for many years. Can you tell us how many years?
It's 20 years.
Is it 21 years or more?
When I was invited by Judge President Blambo to come and act in Gauteng, I did not know him before then. And I think he knows me by now. And I don't think from where I am sitting and from his knowledge, he sees the person that, or he knows the person that perhaps I am made out to be. When I arrived in the Western Cape, I did not know Judge President Hlophe. I have worked with him. I have worked under his leadership. And I don't think outside the position that he knows, and perhaps even Justice Mlambo may know, that I share the view of the difference of opinion on the location of the magistracy. All right? But the person and the temperament and the respect, I think those are two a little bit removed from the person that is before you, Minister.
CJ, with your indulgence, I forgot to ask you one question.
Please go ahead, Honorable Minister.
Yeah, on the first one, I thought you will also brag about the program you have started with the Deputy Minister of Correctional Service that leads to the magistrates training to visit the centers. I thought you would say more.
Yeah, thank you, Minister, for highlighting that. What is happening now is that observing that perhaps magistrates make orders and sign warrants of detentions to incarcerate people without knowing the conditions under which people actually reside within a prison facility. It actually started within my own administrative region. I took magistrates to the prisons within the administrative region. And I also visited prisons with my Judge President in the Western Cape, Judge President Hlophe. But we then moved that on, and it was in consultation also with the input of Judge President Hlophe that the training of the magistracy in the Republic now includes a day where magistrates are taken to prisons physically to go and see what is happening there and the circumstances under which people live. So as part of our strategy to highlight especially the human rights culture and what I call the conscience of the Constitution into their decision making.
Thank you, CJ, and thank you, Mr. Thulare. You said we must say Mr. Thulare.
Thank you.
Thank you.
Thank you, Honorable Minister. Professor Schlemmer.
Thank you, Chief Justice. Good afternoon, Mr. Thulare.
Good afternoon, Commissioner.
Would you mind sharing your judicial philosophy with the Commission?
Maybe just starting on my last comment, I strive to ensure that whoever reads what I have written can actually feel the conscience of the Constitution in the judgment. The rights entrenched in the Constitution, the values of the Constitution in what I write. And I would say that is my philosophy.
What is your understanding of the rule of law?
Primarily that the Constitution says it is the supreme law of the country. That's the starting point. But the values in the Constitution, and especially that all citizens are equal before the law and must enjoy equal protection of the law. And that laws must be certain. They must be known as well. They must exist before one can be said to have breached it. That for me is the essence of the rule of law. The process, the institution, the norm.
Chief Justice, if I may follow up.
Please do.
Would you say that the system of precedent forms part of the rule of law?
It does. But in the Republic, one needs to be careful. Because remember, I can still open a law book and find a statement that reads, memory like a woman is always unfaithful.
I think draw that.
I would withdraw that, but it is in a case law. And I'm trying to drive home the point that the cases that you read and that you apply, you must go back to the Constitution and see that it aligns with it.
If I may follow up again. In one
Please continue, Prof.
In one of the cases that you decided, it was overturned, and the judge Henny, said in that case you didn't follow the line of precedent that was valid at that point in the Western Cape. How did it then happen that you didn't follow the precedent in that case?
I have explained the position in the previous interview, and I also think in the response that I sent to the Commission, I did explain. The case referred to is NGJ Trading. It's an appellate division case. I understood it differently to Judge Henny. And remember, as I pointed out also in the response and previously, I was not sitting alone in the Madina case. It is a judgment of two judges. I was the scribe, but Judge Dolamo agreed with me. And we did not disagree with the precedent in NGJ Trading. There is a difference of opinion as to what NGJ Trading says between Madina and Mu, which is the judgment of Judge Henny.
Okay, I'm not going to belabor the point. Thank you, Chief Justice.
I can just, maybe just, if you allow me, Chief Justice.
Please go ahead, sir.
Say, that judgment taught me one thing. And that is, I always took the approach that a judgment is different from a doctoral thesis. You don't necessarily have to recite everything that you have read. You only have to cite what you found opposite in your reasoning. All right? But after I read more, I realized that perhaps I should have cited NGJ trading and also cited from it why we were saying what we were saying. But because for me, it appeared clear as to, in NGJ trading itself, that trivial offenses do not become previous convictions. I took it for granted that it will never raise an issue. But I've learned from Madina to say, when you are in doubt, put it in.
Nothing.
Advocate Madonsela SC.
Thank you, Chief Justice. Once again, good afternoon, Mr. Thulare.
Good afternoon, Commissioner.
Recently this year, we received the news of the passing away of His Majesty, the King of our Pedi, King Victor Thulare III. Are you in any way closely related to His Majesty?
I am related, but not close.
And what is your view about the role of traditional leadership in our constitutional democracy? Should we have kings and queens ruling in the enclaves of their nations?
They have a role to play in the constitutional democracy. And to my knowledge, their courts also feature in Section 166 of the Constitution.
Regrettably, as other courts, not
yes, yes,
as a relegate of
yes,
some other institution.
Yes, but it is arising out of an act of parliament, which is the Black Administration Act, and it's part of our law, regrettable as it may be. But so they have a role to play. Currently, South Africa is struggling, in my view, with norms and standards of behavior, especially by our young people. And traditions had ways and customs had ways of how young men were prepared and how young women were prepared for the life ahead and for the crisis of puberty. And amongst others, my view is that if we strengthen the social role amongst others of traditional leadership, we may find ourselves in a better place.
Thank you, Chief Justice.
Thank you, sir. Advocate Tennessee.
Thank you, Chief Justice. Sorry for the delay in turning on my microphone. I have been covered.
Thank you very much.
JP, CJ, it's my turn, Mlambo.
Yes, sir. It is your turn, JP.
Thank you, Chief Justice. Bamshad.
Tobel.
It's been a long time.
Yes, it is, JP.
Yeah. My first question is a follow-up to the question by Commissioner Tsepe about the Jason Smith and Michelle Smith against the NDPP and two others. It's a judgment that it was delivered on 19 March 2020. It had to do with the two applicants requesting the unfreezing of some funds in terms of the poker legislation for living expenses. I'm trying to give you those facts for you to remember, if possible. A reading of the judgment suggests, in fact, it shows that the affidavits regarding the application were filed towards the end of November and at the beginning of December. And the judgment itself, the opening paragraphs, does say this is an urgent application. So I just wanted to check with those facts whether you remember this judgment, because if the affidavits were finalized around November, December, I would think it would have been heard either end of December or in January. You still don't remember the matter?
If you refer to a poker matter relating to the release of some property for purposes of life support, I have a recollection of that matter, JP.
Yes.
Yeah, but to my knowledge, it did not take that long. I took time to ponder the judgment. But I'm speaking under correction, but it didn't take that long.
Yeah. Okay, well, the date reflected that it says judgment delivered 19 March. I'll leave it at that. My question, CJ, is relating to the issue of collegiality or collegiality amongst judicial officers. How do you understand that term?
It means that there must be some level of respect and deference, and I don't want to say friendship, but some benevolence that one must enhance when dealing with other colleagues.
Is it an important trait in the judiciary, especially?
It is very necessary, JP.
Thank you. One of the annexures sent to us is a letter that refers to you, that inquiries must come to you. And I'll be corrected by this commission because I wasn't here in 2019. But it appears to be a statement that was issued after your interview relating to a statement that Jwasa made to the president of the country about his concerns about judicial governance. I may be mistaken if I say after.
That is a discussion document, Chief Judge President.
Yes.
It never reached the president. It was never intended for anyone other than members of the National Executive Committee of Jwasa. It was a collation of ideas within the NEC.
I see. Okay, yes. So you say it was never meant for the public. So it's not an official Jwasa public document?
No, it is not. In fact, if you check the further attachments, you should come across a letter from the president of Jwasa indicating that that document was leaked. It's, in fact, the president goes so far as to say it is a stolen document.
Yes. Okay. Now, thank you very much for correcting that, because that document contains strong language against the Chief Justice and the Deputy Chief Justice.
Yeah, that as I say, it is a stolen document. It is a collation of Let me put it this way, JP.
Yes.
before JOASA reaches a decision, there are what we call deliberative thoughts that comes from all quarters. And one of us is assigned to collate them into a document so that we can distribute it and start discussing it. All right. So that document is an internal document of JOASA. Number one, it was made in confidence. Number two, as I said, the first one is that it's deliberative thoughts. It's not even a decision of the NEC. The NEC had not reached a stage where it deliberates on it.
Mr. Thulare, let me allay your fears. You've explained the nature of the document, and I think you run the risk of repeating yourself.
Thank you.
What you're going to tell us.
Thank you,
You've explained to us, but if other commissioners feel I should give you time, they will say so to explain yourself. But I accept what you say about the document.
Thank you, JP.
But let me just raise, sorry, Chief Justice, the issue of judicial governance. I'm talking to you now as a colleague. We are colleagues, after all.
And as my leader, JP.
I don't know about that, but anyway, I'm joking. We've had many discussions, me and you. Even when you're in Cape Town, we talk about a lot of things.
Yes.
But do you agree with me that the issue of judicial governance under the Chief Justice, the Constitution is clear, but the institutional model, as well as the final location of judicial governance, remains work in progress? Am I correct?
Yes.
Okay. Because I just wanted to understand what the thinking of JOASA is of addressing this issue, because there may be unfair criticism when certain things are not moving.
Yeah, perhaps there's a level of impatience with the input of the magistracy into the greater framework. Because as I say, you'd recall that I made reference to Section 8 of the Superior Courts Act.
Yes.
That the understanding of JOASA is that heads of courts, specifically in Chapter 8, not in the rest of the Superior Courts Act. Because if you look at, let me start by saying Chapter 3 of the Superior Courts Act deals with governance and judicial administration.
Yes.
All right. And then before you get there, when you look at the preamble, especially after noting that, you will see that one of the observations that the legislature makes is that magistrates were not part of the judiciary pre-1994. And one of the objects of the Superior Courts Act is to make the magistracy part of the judiciary. All right. And on the other hand, we are sitting with cases like Armsa versus the President, where the Constitutional Court made it very clear that the magistracy is part of the judiciary. All right. Now you have that. Against that background, then you approach Section 8 of the Superior Courts Act. And as I say, Section 8, yes. You will see that Section 9, 10, 11 specifically refers to the Superior Courts. But Section 8 doesn't. And it spoke to governance, which is the area that the preamble says it is the intention to address the governance of the magistracy. And now you find a situation where the heads of courts meet, less the magistracy. And it is that aspect that JOASA is concerned about. And it is there where there is a difference of opinion and perhaps a push, perhaps unfairly so at a faster pace than perhaps the judiciary can move to say the magistracy must be part of the governance because the Superior Court Act says so. Because the understanding is that the head of court in Section 8 is not as defined in the Act itself, because it must make room for the preamble. So that's where the issue is, JP.
No, I understand. But
yes,
to my recollection and knowledge, I have yet to deal with a formal request for engagement by either the Chief Magistrates Forum or the Regional Courts Presidents Forum to the Chief Justice or to the heads of courts to discuss governance per se, unless I'm mistaken.
I happen to chair the Chief Magistrates Forum, JP.
Yes, that's
and
what I'm
it is a
raising.
message that I will take back to the forum.
Yeah. Thank you. But you agree, sorry, Chief Justice, that collegiality is the glue that keeps judicial officers together. It's not kowtowing or friendship, but respect for each other.
That is correct.
Thank you, Chief Justice.
Thank you, Judge President. President Maya.
Thank you, Chief Justice. Good afternoon, Mr. Thulare.
Good afternoon, President.
Just one issue remains for me. You've covered all my other concerns. All interested parties, including this commission, have lamented the slow pace of gender transformation in the judiciary, as we all know.
Yes.
Now, what I'm going to put to you is something that it's a question that was asked of me by a member of the public, during last week during these hearings, and I'm just going to paraphrase it, to package it nicely so that it's more palatable for a public forum. Now, the JSC, this is what this person pointed out to me. JSC has 23 members, and only 8 of those members are women. Now, should we worry that the body tasked with facilitating the racial and gender transformation of the judiciary itself has very few women in its own ranks? As this person put it, why should the JSC be trusted to execute its mandate to bring gender diversity into the judiciary when its own house is not in order? What thoughts would you have on this?
Within the organized profession of judicial officers, the discussion has already started, and fortunately this one hasn't been leaked, all right, but the discussion has already started about the need, even for argument's sake, for the South African chapter of the International Association of Women Judges to have a permanent seat on the JSC. And it is an initiative that I would personally support. But yes, it is indeed true that if we are to transform in truth, one of the things that we must do, and I'm saying this as a man, is to push back the frontiers of patriarchy and assert women and promote them where necessary and support them to assume positions of leadership, which includes representation at the JSC.
Thank you. Thank you, Chief Justice.
Thank you so much, Honorable President. Honorable Malema.
CJ Toben.
Tamahosh.
Lagasubat.
Christmas.
No, CJ, that issue of gender, I think Makabanega Tambo, they had it. They will attend to it because these ones who come from parliament, it's them who are distorting the composition of the JSC. So it's something that parliament will have to look into. Mara, what I wanted to say, Tobe. Thank you, CJ.
Thank you, sir. Advocate Thulare, I have a few questions. The first flows from what President Maya asked you.
Yes.
Supportive as you are of gender representation, we have 2 women advocates who have applied here, 2 African women. Would you favor a notion that instead of recommending you for appointment, we should rather recommend those 2 women for appointment since there are only 2 vacancies?
Similar to my answer to Commissioner Breitenbach, I leave that to the wisdom of the Commission, Chief Justice.
I'm sorry, sir. I know it's not fair. You are passionate about gender transformation. You are even a member of the International Women Judges Association. Would you, in view of your passion for gender representation, say, painful as it is, I'm going to give way to my two sisters so that they, instead of me, can be appointed?
If the JSC finds that the Western Cape deserves what the two women offer in the greater scheme of things, better than what Daniel Thulare can offer to the Western Cape and to the judiciary, I'll be at peace with that, Chief Justice.
Okay, sir. My next question, instead of reading something, I'm going to play a clip. Don't worry about the content. It's not about what you are advocating. I'm not worried about that. It is about the song itself. My question arises out of the song. Technicians, please play that song. My question is based on it. Is it
at
coming?
the next meeting of JOASA, as well as the next meeting of the SACIAWJ, I will be leading a song whose lyrics goes like this. Phakama mandisa maya, ixesha lisondele. Phakama mandisa maya, ixesha lisondele. In my view, the judiciary is bleeding and rudderless. It needs a calming leadership. I am of the view that South Africa is ready for the first African female Chief Justice. The current most senior female judicial manager is the President of the Supreme Court of Appeal. It is the woman, I think, the Magistracy should unequivocally and unconditionally and unashamedly at this stage call on for the President to look at. There is a song whose lyrics goes, African woman, why give me Korobela? I think the beginning of the lyrics should remain African woman, but the last portion we should change. Give us justice. That would be the views of Daniel Mafele Thulare, and I will, without hesitation, be expressing them when I come back from the 6th of July 2020. All the best, colleagues.
Now, my question is very narrow, sir. Is it you in that clip?
It is myself, Chief Justice.
Is it correct to say that song is a song associated with a political party, the ruling party? It is a song that was popularized by the presidential campaign of President Cyril Ramaphosa when he wanted to be president of the ANC. Is it correct to say so?
Perhaps before I answer the question, Chief Justice, let me state the following. That clip.
Sorry, sir. I'm going to be very fair to you. Can we agree that you answer my question and then I'll allow you to give whatever perspective? Let's just start on the narrow issue. I'll be very fair to you, sir.
I have heard it sung across political lines. That is correct, Chief Justice. That it was sung in political rallies, but across political parties, not restricted to a particular political party.
So it is not associated with the governing party, and it is not particularly associated with the current president?
No, not at all. And it was never intended to be.
Okay.
Yeah, but
okay.
Can I please make this comment, Chief Justice?
Okay, sir. Okay, sir.
This clip falls in the same category as the document that Judge President Mlambo earlier referred to. It is a WhatsApp voice message to magistrates serving at the Cape Town Magistrates Courts. When the president announced the lockdown, I was in the Western Cape, and I took a decision to lead my colleagues from the front, being in the Western Cape during the first lockdown up until towards the end of June. I was in the Western Cape. When the lockdown eased and the country could move and the courts could open, I then took leave of absence. Now, ordinarily, this would have been a tea room discussion. It was meant for the confidence of colleagues in a tea room in Cape Town. But because I was on leave, I was here in Gauteng, I learned that the discussion around the succession within the organizations have already started. I don't think Jwasa was the only one, because although we do not formally engage, but informally across associations, we exchange notes. And the discussion had commenced within the magistracy. And the only way that I could make a contribution to that discussion was through a WhatsApp voice note. And that is the context. So it was never intended to go public. It was made in confidence. It is part of the deliberative thought processes towards decision making. That is its status. And most importantly, it was given to people who are members of the organization who owe a fiduciary duty and a professional as well as ethical responsibility to keep things confidential. And one of them breached that. And that's why it is now with the Chief Justice.
Okay. Now,
perhaps deliberately to embarrass Daniel Thulare, I do not know. But that's its status.
Okay, sir. Now, did you say, let me put it in. Have you ever heard this song sung outside political party circles?
Yes.
So you can sing it even outside the political, so it has been sung outside political party structures?
That is correct, Chief Justice.
Okay. Now, you were the one singing. You were the one saying the judiciary is bleeding and rudderless. It was not Joasa. It was your message to your colleagues. What have you to say about that?
That interpretation is incorrect, Chief Justice, because I am saying I will be leading And you don't lead unless there are people in the choir. And as I say, I was here in Gauteng when I was informed that the discussion had already commenced and people made their views known. And I also made my views known in that discussion.
Okay, sir. Finally, following from the 2019 engagement
Chief Justice,
regarding whether the magistrates
Chief Justice,
were not, sorry, sir.
Yeah, it's Julius Malema.
Yes, sir.
I don't know how this is done because it was played here in public. It's unprecedented what you just did.
Yes.
And I don't know how to handle it because I thought people write objections and then they are given to candidates and candidates are given sufficient time to prepare a response. And I view that as an ambush. And I'm very uncomfortable about it. And it was done here in public. I know we can go and take up a discussion in our own deliberations, but I don't accept that. I'm very uncomfortable about it, and I'm very uncomfortable at the way it was presented. Has never. I've been here since 2014. It has never happened. It's for the first time. So I don't know whether, in the language of lawyers, is an admissible evidence that gets to be presented in this way, or what happens, because it can be that other people should follow a certain procedure when they've got issues with the candidate that comes here, and the Chief Justice has got a special procedure which he follows, because he was supposed to be given an opportunity that you are going to be led on this so that he can prepare sufficient a response like all other people who object. I don't know how we go about it. To me, it's unfair. And I will suggest that perhaps even when we go into the private discussions, it must not arise. It must be withdrawn completely because it didn't come through the established practices.
Yes. Well, for the record, it was on the 1st or the 2nd of April that the candidate and all the commissioners, including you, Honorable Malema, were sent the documentation and the clip that has just been played. So there's no ambush here. It may well be that you didn't access it, but it was sent to everybody. Ask the candidate whether it was sent to him. It was. There is a record of that. So there's no ambush here.
No, then it's fine.
There's no special procedure here.
If the commissioners received it and it followed a normal procedure and he had an opportunity to listen to it and reflect on it like the rest of others, then I withdraw my proposal.
Thank you, sir.
Chief Justice?
Yes, sir.
It's Singh here. And if I can recall, President Maya also gave notice to all the commissioners that she will be raising this matter at the JSC in writing.
Yes, yes. Thank you, sir. Now, my final question, sir, it is to give you an opportunity to correct, if you are so minded, the assertion you made in 2019 during the interview that on the 3rd of October 2019, nothing was said about the magistrates, nothing was said about their performance. In the prior communication, I refer to page 31 of the annual judicial accountability report that shows what the report says about the regional court and what the report says about the district courts. And even in the speech I delivered, which I attached and sent to you and the commissioners, paragraph 25 makes specific reference to the magistrates. And most of the time, I don't refer to judges, I refer to judicial officers, which includes both judges and the magistrates. So my only question is, do you realize that you were mistaken, or do you not realize that you were mistaken in your assertion that magistrates were not even mentioned? They were just sitting there, but nothing was said about them.
Chief Justice, if I recall, the context of the discussion was in relation to the performance as demonstrated in the document with regard to, and I was making a comparison of what was in the document in relation to the higher courts or the superior courts and the magistracy. It is in that context. If I gave, because I was away, as I said, I was at the meeting, I heard what you said, I had received the report, I had read it. I knew what stood in the report.
So you were aware that specific reference was made about the magistracy and about what could not be specifically mentioned.
The context, insofar as I understood the discussion at the time, Chief Justice, of my interview, it was talking to the performance of the courts. That's how I understood it. And the agreement on the performance indicators is in the document. I knew that. Remember, I participate in the meetings with Judge President Musi. So I know what the situation is.
Okay, sir. Now, thank you very much, Advocate Thulare. Thank you very much, sir.
Thank you. May I please,
sorry. President Maya has a...
Thank
yes,
you.
Sir. Yes.
Mr. Thulare, I'm deeply flattered that you think I could actually lead the judiciary. Thank you. But I don't want my name to be collateral damage in this tussle between you and the Chief Justice. Would you please do one thing for me and tell this commission and South Africans just what role I had, if any, with this push by Jawasa to propose that Mandisa Maya should be the next Chief Justice? Please.
Thank you. I think the Chief Justice himself would attest to that. When Jawasa has its own internal discussions around the succession of the Chief Justice, we do not consult the candidates that we identify, neither do we speak to them. I'm making specific reference to the Chief Justice because even in the letter that the President of Jawasa wrote, that has been given to the commissioners would have noted that the President of Jawasa makes reference to the time leading up to the interview of the Chief Justice for this position. So the Chief Justice is well aware himself that Jawasa does not talk to candidates. We never approached him, nor he approached us to say, I want to be Chief Justice. So the same position prevailed with Justice Maya. We discuss amongst ourselves, and as I say, unfortunately, the document was leaked, whether generally or specifically to embarrass Daniel Thulare, the jury is out, but the document was the thought process for Jawasa to make a decision. And I have to state here, President Maya was not the only candidate that the NEC of Jawasa discussed. There were other people. In fact, the other name is one of the JPs present here. All right, that was the discussion. But we were in the preparatory space. We have never discussed with anyone, and therefore we had never discussed with Judge Maya. In fact, I think Judge Maya became aware, if she received the leaked document when it went public, that Jawasa was actually discussing her name. But we don't generally discuss candidates with them or lobby them or go to them to say we are going to be proposing you. We have our own internal discussions, and once our processes are concluded, then we communicate publicly.
CJ, if President Maya is done, I want to make a follow-up.
I'm done, Commissioner Malema. Thank you very much, Mr. Thulare.
I would like to follow up on that.
Yes, sir. Let me just have your name. Who comes after Commissioner Malema?
Mr. Dovu,
I'll follow Madonsela. Commissioner Madonsela, CJ.
Nyambu will follow Dovu.
Okay.
No.
Thank you.
I just want to...
Honorable Malema, over to you, sir.
I just want to get a clarity. You said something like the current Chief Justice was discussed in the same manner Justice Maya was discussed.
Yes.
Can you take us through that process?
I'm saying leading up to his interview to become Chief Justice, at that time, as an organization within the legal profession, we also had discussions about who is going to follow Chief Justice Ngobo. We have our own internal discussions. So yes, we discussed the Chief Justice. In fact, if you can, perhaps even if I recollect correctly, during his interview, Judge President Ngwepe read out a portion of Joasa's contribution. The Chief Justice, to my knowledge, learned about that for the first time when it was read. We never consulted him. We don't, as a matter of principle.
Did you have a song for him?
We didn't sing for him at that time.
Thank you. Thank you, CJ.
Thank you, Honorable Malema. Well, Honorable Dodovu, I've written your name before that of Advocate Madonsela, so please go ahead first. I don't want to confuse myself.
Okay, thank you very much, Chief Justice. Some few questions from my side. Perhaps can you just share with us in brief, and I'll tell you why I'm asking this question. Do you know the process of appointing a Chief Justice?
Yes, I do.
Can you just share with the Commission a bit?
The President makes a determination and thereafter discusses it with members of political parties.
You do know that this body, the JSC, ultimately is the one that recommends to the President?
Yes.
What would be, under the circumstances, the role of Joasa and any other interested party in the process?
To comment on the candidate, which is what we did with the current Chief Justice.
Your singing of the song was based on how you are going to present your recommendation, your comments in the process?
Yes, it's preparatory work towards a decision, and that decision then, so that by the time the process kicks up, Joasa is ready. Remember, we are the leadership. So you prick the members to start discussing, and then the discussions of the members they become collated, and then once they are collated, they are taken back to the members for thumbs up, and once it is there, then we are in a position to make a comment.
In the song that you were singing, you were just saying to the members, this could be our view. You were lobbying them that this could be our view in supporting whoever is the candidate.
Yes.
In that respect.
Yes, and remember, the organizations are democratic, all right? I, together with those that spoke to me, spoke to a name. It could be that during the deliberations, we could have agreed on a woman, but not President Maya. One does not know how the discussions would have unfolded. But you put your head on the block and say, this is where we are going, and for people to comment, and because it is a democratic process, and commissioners must bear in mind, the very organizations, all right, made the nomination for me to say, this is a candidate to be a judge.
And then this song that you are singing, it was not intended for any of these commissioners?
No. It was intended for magistrates within their organized professions. And specifically, the song was for magistrates of Cape Town.
And you were not intending to lobby any one of us, the 23 members here,
no,
about your preferred candidate?
No.
Okay, thank you very much. I'm satisfied.
Thank you.
Advocate Madonsela SC.
I'm covered.
Honorable Nyambi.
I am covered by Commissioner Malim, but I wanted.
In the nature of my work, I interact also with lay people, with members of the public. I have never had anyone complain about the treatment that I meted out to them. In fact, even ordinary members of the public had sometimes written to me personally and to other people commending how I deal with them. I also participate in public outreach programs. I have been on Cape Talk. I have been on many radio stations, interacting with members of the public. The person referred to in that comment is actually a stranger to me.
Thank you. Can you hear me?
Yes, I can.
Oh, okay, thank you. I've lost my picture.
Chief Justice, can I have a follow-up? I don't know whether Commissioner Breitenbach is posing another question.
Let me first clear up with Honorable Breitenbach if she's done. Have you finished, Honorable Breitenbach?
No, I have one more. I have one more question. Sorry, Chief Justice. I've lost my picture. I don't know why, but anyhow.
Okay. Is it related to the first?
No.
All right. Please allow me to have Advocate Madonsela SC come with a follow-up, and I'll just make a note so I don't forget that you haven't finished. Please go on with the follow-up, sir.
Thank you, Chief Justice. Good afternoon, Mr. Thulare.
Good afternoon, Commissioner.
In your acting stints, have you ever had an occasion where you were presiding as a judge and you had a heated debate with a counsel appearing before you?
No, I never had that.
Thank you, Chief Justice.
Thank you, sir. Honorable Breitenbach, over to you.
Thank you, Chief Justice. Mr. Thulare, what are your views with regard to a judicial officer who has been found guilty of gross misconduct linked to underlying dishonesty continuing to sit on the bench?
I am seated here telling the commissioners and the rest of the Republic that I am ready to be a judge. That means that I have respect for constitutional structures, that in terms of the Constitution and the law have a duty to pronounce themselves on matters that are opposite to be dealt with by them. As a consequence, I have no view.
Thank you, sir. I'm done.
Honorable, have you finished, Honorable Breitenbach?
Yes, thank you, Chief Justice.
Thank you very much. Honorable Singh?
Thank you very much, Chief Justice, and good afternoon, Advocate Thulare.
Good afternoon.
Yes. I remember a previous interview which I was part of from this commission where we asked you about certain remarks you made as outgoing president at Jawasa. I think it was in July 2019. And I think this relates to judicial temperament. And I just want to know, you made some remarks which, and if I could just quote, well, one of the things, you were quite critical of the current structure, which saw chief magistrates and regional court presidents sidelined and absent from the hands of court meetings which were convened by the Chief Justice. And amongst other things you have been reported to have said is that the office of the Chief Justice is not a, and I want to quote, judicial kingdom, close quote. Now, I just want to know from then to now, have your view changed? Are you still of that still strong view that you had then, which you made in public? If you can just let me know, please.
I have allowed myself to be led by the organization that I led at the time. And the views that are referred to were the views of the organization. So I have to state that point clearly. When I often say democracy can be cruel because it is the outcomes of the majority view I think listening to Commissioner Breitenbach, perhaps that's the space where she finds herself. I'm not sure where there is a democratic outcome, but you're uncomfortable with it. But the point remains, once it is a democratic outcome, you're bound to it in a constitutional democracy. So those comments were made in that light. I can inform the Commission that there need be no fear of Daniel Thulare as a person, because I am of the view that yes, there is a difference of opinion which I have to acknowledge that exists between the Judicial Officers Association of South Africa and the leadership of the judiciary, which speaks to governance, and in particular, maybe just reference to prescripts, the informed from the preamble to the Superior Courts Act and the interpretation specifically of Chapter 8 of the Superior Courts Act and what heads of courts there mean, whether in fact the meaning there is the meaning in the definitions or it's broader. That's the narrow part. But the whole question relates to a single judiciary. It is a complex matter which I believe cannot even be resolved by a debate and or questioning during an interview. It is a matter, in my view, that is best left for the judiciary itself to deal with it. So that is my current view. And moving into judgeship, if I am favorably considered, I will continue the engagement, and if the majority decision, even within judgeship, is that no, the judiciary commences with the high courts upwards, the magistracy is not, that would be the environment in which I find myself, of the indigenous churches in the Republic. I think if you drive around town sometimes on a Sunday, you will see a group of people under a tree, some of them dancing around. Those are the churches that I'm speaking to, and I'm a member of that faith. And I wrote the book informed by that. But Commissioner Singh, I appreciate that a judicial officer, in my view, has got two beings. You have your private being and you have your public being. And the two are different. When you sit in judgment and ordinarily in your conduct, your public being, your judicial being must take precedence. But the manner that I pray, and whether one of the things that is in the book is reverence to ancestors. I do revere them, and I trust in God. That's my private being. All right. Even before I took the trip to this interview, I took the time to reflect and speak to my late mother. That's how I am, and that's my belief system. All right. So, but whether it will influence my thinking on the bench, on the public being, I will only be, and I've always been, influenced only by the facts and the law.
I think Advocate One is entitled to their personal beliefs, conflict with when you sit on the bench. But I just want to contend that there's a fine line between your personal being and sitting on the bench. And just as a follow-up, what is your view on corporal punishment? Did you write anything about corporal punishment at home in your book?
I don't subscribe to that. I don't subscribe to corporal punishment at all. I've raised kids. the youngest one is in university now. I've never beaten any one of them.
Thank you, Advocate, and thank you, Chief Justice.
Thank you, Honorable Singh. Commissioner Tsepe.
Thank you, Chief Justice. Good afternoon, Advocate Thulare.
Good afternoon, Commissioner.
My first question, I want to, it's a bit of a follow-up to the Chief Justice's discussion with you on reserved judgment.
Yes.
And I just wanted to talk judiciary.
That aspect is very necessary. I have both in Gauteng and in the Western Cape. I had in Gauteng. I had the privilege of serving as an acting chief magistrate, both in Pretoria and in Kempton Park. And it is during that time that I started observing that, let's say, for instance, let's talk about civil litigation. If you go to many magistrates' courts across the country, you still find that the majority of presiding officers in the civil courts still happen to be our white compatriots.
Are mostly confined to criminal, equality, and immigration law. Do you have a comment on that?
Where I'm sitting, the magistrates' court in Davidson.
CJ, and good afternoon, Advocate Thulare.
Good afternoon, Minister. Who was appointed to Stellenbosch in 2013. Now, intervene in respect of the training and the production of the report. And all of them also concluded that the problem lay with Mr. Amos and his capacity to train and guide. To assessing whether there was compliance. What makes us great is that whenever there is tension, it has never flared up into open conflict because of the greatness that we are. So we are a good constitutional democracy, and we are in our space. Thank you.
Thank you very much. I think, Chief Justice, in the interest of time, I will stand by that question.
Oh, I know how to receive a box and pack it on a trolley and push it in. So that's where I was of the view that he was not the right candidate to lead Stellenbosch. Advertised. I obviously discussed this question with the Magistrates Commission at the time. After the whole process was done, Mr. Amos then challenged the appointment and argued that.
Thank you, Chief Justice. Thank you, sir. So I don't forget that you haven't finished. Please go on with the follow-up, sir.
Thank you, Chief Justice. Good afternoon, Mr. Thulare.
Good afternoon, Commissioner.
In your acting stints, have you ever had an occasion where you were presiding as a judge and you had a heated debate with
Malema?
Honorable JP Fabe, who's next? Moema? Honorable Moema?
Malema.
Is that on Malema?
Yes.
Thank you. Honorable JP, over to you, sir.
Thank you very much, Chief Justice. Excuse me. Thank you very much, Chief Justice. May I also place on record that I've known Mr. Thulare since his appointment as a Chief Magistrate, and that was in 2016 when we met. Mr. Thulare, just remind me, you have acted in Cape Town. How many terms altogether in the Western Cape High Court?
It was the last term of 2017.
Yes.
All the terms of 2018, the last 2 terms of 2019, and the first term of 2020.
So that's a total of 8 terms, am I right?
That is correct,
8
Judge
terms.
President.
Right. May I also confirm for the record that Mr. Thulare, when he acted, he did not reserve judgments for an unduly long time. And the judgment that he is talking about, I think he reserved it for about 4 months or so, Mr. Thulare.
That is correct, Chief Justice, AJP.
And indeed, he did discuss that with me. Other than that, I have no questions for this particular candidate. Thank you very much.
Thank you, JP. Honorable Premier.
Thank you very much, Chief Justice, and good afternoon, Advocate Thulare. Sorry, it's Magistrate Thulare, or Mr. Thulare.
Mr. Thulare suits me fine. I am an admitted advocate of the High Court, by the way, but Mr. Thulare suits me fine.
Or Advocate Thulare, thank you very much. And good afternoon.
Good afternoon.
I think my first question, as I've asked to everybody, I'm a proud South African. I think that we have an amazing constitution. But of course, I'm a politician and I sit in one of the separate spheres where we have separation of powers. And my question to everybody has been, in our young democracy, and specifically,
Was appointed in the Western Cape. He was already acting as a senior magistrate. Observation was that when he went through the work of the aspirant.
No, I have one more. I have one more question. Sorry, Chief Justice. I've lost my picture. I don't know why, but anyhow.